Hi, good afternoon, ladies and gentlemen. My name is Everett Price. I'm a senior policy advisor at the U.S. Helsinki Commission. And on behalf of Chairman Joe Wilson, Co-Chairman Ben Cardin, I would like to welcome you to this Helsinki Commission briefing on countering authoritarian abuse of Interpol. Interpol is the world's largest law enforcement coordination network, featuring 196 member countries. In effect, Interpol provides a way for the world's law enforcement agencies to share information and communicate to fight crime. Many have heard of Interpol's red notices, one of a number of color-coded notices and other bulletins that law enforcement agencies can distribute using Interpol's global communications network. In conducting its work, Interpol is bound by two key provisions of its constitution. Article 2, that requires the organization to act in the spirit of the Universal Declaration of Human Rights, and Article 3, that bars Interpol from facilitating law enforcement requests of a political, military, religious, or racial character. Sadly, we know that Interpol member countries for years now have been violating these provisions and abusing the organization's resources to circulate politically motivated or otherwise fraudulent notices. These notices constitute a form of transnational repression, since they enable a government to harass, intimidate, and possibly apprehend political dissidents, journalists, activists, and common citizens and their families virtually anywhere in the world, including here in the United States. To combat this troubling phenomenon, the Helsinki Commission led the introduction and passage of the Transnational Repression, Accountability, and Prevention Act, or TRAP Act, in 2021. The law required the executive branch to file periodic reports on Interpol abuse and U.S. efforts to stem this abuse by enacting domestic safeguards and promoting reforms at Interpol headquarters. For the first time, it legally prohibited U.S. agencies from extraditing individuals solely based on Interpol communications. Important legacy of the TRAP Act, lesser known though, was the role that it played behind the scenes in creating the transnational repression reporting that was featured in the State Department's annual human rights report every year since 2019. Although the law has borne some fruit, the Helsinki Commission has been concerned that U.S. agencies are not adequately implementing its provisions. Our leadership earlier this year sent a letter to the U.S. State Department and Department of Justice insisting that they address shortcomings in their periodic reports. The State Department subsequently responded and has committed to improving its submissions, beginning with the 5th iteration of the report sometime next year. As we approach the 3-year anniversary of the TRAP Act, we are joined by this distinguished panel of experts to take stock of what the law has accomplished, where implementation has fallen short, and what remains to be done here in Washington, at Interpol's headquarters in Lyon, France, and elsewhere to counter authoritarian abuse of Interpol. This is a particularly appropriate time to be convening this discussion, as Interpol next week will hold its 92nd Assembly meeting in Glasgow, where it will elect a new Secretary General and 9 members of the organization's Executive Committee. The outcome of these elections will have significant implications for Interpol's trajectory in responding to politically motivated abuses. So without further ado, I want to introduce our distinguished panelists. We will go in order from my right to my further right, I guess. So we'll begin with Dr. Ted Broman, founder of Broman Expert Witness Services. Dr. Broman holds a PhD in history from Yale University. He taught history and international relations at Yale from 1999 to 2008. From 2008 to 2024, he was senior research fellow in the Margaret Thatcher Center for Freedom at the Heritage Foundation, and he is now the founder and sole proprietor of Broman Expert Witness Services, which provides strategic advice and expert witness reports in cases of Interpol abuse, and the policy director of the Pursuit, an NGO focused on opposing transnational repression. Following Dr. Broman, we'll hear from Mr. Megre, Charlie Megre. Charlie Megre is a French lawyer specializing in Interpol-related legal matters. From 2017 to 2023, he served as a legal officer at the Secretariat of the Commission for the Control of Interpol's Files. In this role, he processed requests from individuals seeking the deletion of their data from Interpol's files, which gave him in-depth knowledge of the CCF's jurisprudence and Interpol's decision-making processes. He now brings his expertise to Other Side, the law firm he founded to challenge unjust Interpol notices and defend individual rights. And finally, we'll hear from Sandra Grossman. Ms. Grossman is a founding partner of Grossman, Young, and Hammond, LLC, a full-service immigration and international human rights law firm operating in Bethesda, Maryland. She is an active member of the American Immigration Lawyers Association and is the recipient of ILA's Edith Lowenstein Memorial Award for Excellence in Advancing the Practice of Immigration Law. She publishes and speaks frequently on transnational repression and autocratic abuse of Interpol. So as you can see, we are in auspicious company here and accompanied by spectacular world-class experts on Interpol abuse to walk us through this troubling phenomenon and appropriate responses. So without further ado, I will turn it to Dr. Broman to kick us off with his opening remarks.
Thank you very much, Everett. I'm honored to appear before the Commission today to make this statement on how the United States, by fulfilling the provisions of the TRAP Act, can improve its responses to transnational repression committed through the Interpol system. While the TRAP provisions have not fulfilled the hopes of their supporters, I do credit it with some successes. TRAP has brought awareness to the problem of Interpol abuse. It is because of TRAP and the Commission's dedication that the U.S. has the opportunity to establish leadership in this vital area. Moreover, since TRAP was adopted, U.S. officials have taken leading positions in Interpol institutions, such as the Commission for the Control of Interpol's Files, the CCF. This is Interpol's appellate body. I want to pay tribute to these U.S. officials who have brought a new level of professionalism to Interpol. Finally, I welcome the effort by the United Kingdom, backed by the United States and our Five Eyes allies, to suspend Russia from Interpol after its second invasion of Ukraine in 2022. This effort, while unsuccessful, was in line with provisions in the TRAP Act. But I'm sorry to say that most of the news about TRAP is less good. The TRAP provisions are contained in Section 6503C of Public Law 117-81. These provisions center first on requiring support for Interpol reforms, and second, mandating the publication of TRAP reports by the Departments of Justice and State. The voice, vote, and influence provisions of TRAP have in practice been disappointing. Interpol's reports have not improved. The CCF and the Notices and Diffusions Task Force remain underfunded. Interpol is currently led by a president under investigation for torture. This is not the reformed Interpol that U.S. leadership, guided by TRAP, was supposed to produce. Then there are the TRAP reports. The responsible departments have published a number of TRAP reports, with the first report in August 2022 being the most substantial. Unfortunately, all of these reports fall short of the requirements under U.S. law. The TRAP reports, inter alia, are supposed to provide an assessment of the CCF's March 2017 operating rules and any shortcomings the U.S. believes should be addressed, unquote. The reports do not address the CCF's operating rules or describe any shortcomings. The reports are supposed to describe how, quote, Interpol reviews and addresses cases in which a member country has abused or misused the red notice or red diffusion mechanisms for overtly political purposes, quote. The reports fail to describe how Interpol addresses cases of abuse. The reports are supposed to provide, quote, a description of any incidents in which the Department of Justice assesses that U.S. courts and executive departments or agencies have relied on Interpol communications, unquote. The report refuses to do any of this and simply passes the buck to the Department of Homeland Security. The reports are supposed to, quote, describe how the U.S. monitors and responds to likely instances of abuse of Interpol, unquote. The report provides no information on how abuse affecting individuals who are not U.S. government officials is detected and combated. And the reports are supposed to provide, quote, a strategy for improving interagency coordination, unquote, on Interpol abuse. The report says nothing about improving coordination. Most egregiously of all, while the TRAP provisions require the report to provide, quote, a list of countries that the Attorney General and the Secretary determined have repeatedly abused and misused the red notice and red diffusion mechanisms for political purposes, unquote, the report bluntly and simply refuses to follow the law. Instead, the report states that, quote, the Department of Justice believes such listings could lead to retaliation against the United States and its international law enforcement efforts, and may also diminish the effectiveness of Interpol's law enforcement work with member countries, unquote. I find that failure to follow the clear written word of the law to be utterly unacceptable. The report's most important contention is located on its first page, which states that although instances of Interpol abuse still occur, this particular form of transnational repression seems to have receded since Interpol implemented reforms in 2016 and 2017. The report provides no evidence to support this contention, and in fact, all available evidence refutes this contention. The Department of State's own country reports do not show that Interpol abuse has receded. The country reports show Interpol abuse is probably stable. Data from the CCF also contradicts the TRAP reports. In 2015, the CCF deleted 63 instances of non-compliant, in other words, abusive information. In 2022, it made 296 such deletions. By this measure, Interpol abuse has not declined, it has increased. Or consider the data from the Notices and Diffusions Task Force. In 2019, the task force rejected about 5% of requested red notices and wanted person diffusions. In 2023, it rejected almost 7%. True, the number of rejections based explicitly on Articles 2 and 3 of the Interpol Constitution has declined, but nations can avoid being condemned on these grounds simply by not replying to the task force's requests for information. As a result, while the number of explicitly Article 2 or 3 rejections from the task force have gone down, rejections for lack of cooperation have grown significantly. The bottom line is that attempted abuse, like actual abuse, is certainly not decreasing. By any measure, it is either stable or increasing. The TRAP reports emphasize that the reforms introduced in 2016 and 2017 were valuable. I agree that these reforms were valuable, but the reforms have not solved the problem of Interpol abuse. There are several reasons for this. Interpol abuse evolves constantly. The number of abusive member states in Interpol is increasing. The institutions that seek to address abuse inside Interpol are under-resourced. And Interpol appears to be more interested in expanding organizationally than it is in ensuring that its existing functions are properly funded. Following the law is not optional. TRAP reports must abide by the requirements of U.S. law. But the purpose of that law was not to compel the production of a report. It was to lead to reforms in Interpol, reforms that the U.S. was supposed to take the lead in advancing. The Department of Justice has explicitly acknowledged its belief that reporting publicly on Interpol abuse will reduce the effectiveness of Interpol as a tool for U.S. law enforcement. It is therefore perhaps no surprise that the TRAP reports fail to fulfill many of the requirements of U.S. law and blandly ignore all available data on Interpol abuse. Ms. Grossman and Mr. Megre will advance recommendations for Interpol reform, and I associate myself with their recommendations. In my written submission to the Commission, I advance my own recommendations. But my core recommendation is simple. Both Interpol and the departments behind the TRAP report should remember that the greatest danger to Interpol rests not in the timely exposure of abuse, but in minimizing abuse until that abuse leads to a legal, political, and financial crisis that gravely damages both Interpol's legitimacy and its effectiveness. Thank you very much.
Thank you, Dr. Broman. Really appreciate that, and we hope that we can dig into more of your recommendations in the question and answer session. Mr. Megre.
Good afternoon, everyone. Thank you for giving me the opportunity to speak today about a very important topic, the politically motivated abuse of Interpol channels. So imagine being targeted not for any crime you committed, but because of your political beliefs. Now imagine same governments using a global policing system to restrict your movement, damage your reputation, or even lead to your wrongful arrest. This is the reality for many victims of Interpol misuse. And today I will outline the reforms Interpol has adopted to address these issues and explore additional steps that Interpol and its member countries can take to prevent such abuses. So since 2015, Interpol has implemented several important reforms to help prevent the misuse of its systems. First, in 2016, Interpol established the Notices and Diffusions Task Force, so the NDTF, And this task force ensures that all incoming WEN notices and wanted person diffusions are reviewed prior to the publication by the General Secretariat. And this review helps prevent the circulation of at least some non-compliant notices or politically motivated notices. Second, in 2017, Interpol adopted its refugee policy, generally prohibiting the issuance of WEN notices against refugees. And third, the power of CCF were increased in 2017. The CCF's decision became binding, meaning that if a notice or a diffusion is for non-compliant by the CCF, Interpol must remove it. Statutory timeframes were also introduced to ensure timely decisions and improve the CCF's ability to protect individual rights. So these reforms were important and valuable for sure, but they haven't fully addressed the issue of Interpol abuse. So while the TRAP report acknowledged that Interpol reforms were an important step forward in addressing politically motivated misuse, relying only on those past reforms misses the ongoing challenges. Recent Interpol statistics show that just over 6% of WEN notices and diffusions published in 2023 were refused or cancelled by the General Secretariat due to non-compliance. And at first glance, this seems positive. But as stated in the TRAP report, the misuse has become more sophisticated. And countries now file WEN notices based on charges of fraud or financial offenses that appear legitimate but are politically motivated. And a clear sign that misuse is still happening is the high rate of non-compliance reported by the CCF. So between 2017 and 2022, approximately 70% of the notices and diffusions reviewed by the CCF were found to be non-compliant, so even after the reforms, 70%. And according to the last CCF annual report, most non-compliant cases still involve violation of Article 2 and Article 3 of Interpol's constitutions. So if the reforms had been fully effective, we would expect this number to have decreased. And this shows that while reforms have made a difference, they have not fully solved the problem. So the question is, what else can be done to stop politically motivated abuse of Interpol? And in my opinion, efforts should focus on 3 levels. The first level is at the member country level. The quality of the data submitted is crucial. And national central bureaus, so the NCBs, are responsible for ensuring accuracy and the legality of the data disseminated. And NCBs should be the first safeguard against abuse, acting as the initial filter to ensure that all data complies with Interpol's rules. And well-trained NCBs are less likely to misuse the system. That's why member countries should invest more in training and overseeing the NCBs to prevent abuse. Second, when it comes to the General Secretariat, it's important to note that the Notices and Diffusions Task Force plays a crucial role in reviewing WEN notices and diffusions. And while there is room for improvement in how these reviews are conducted, I want to focus on something that can truly help reduce politically motivated abuse, and it's transparency. The TRAP provisions highlight the importance of both qualitative and quantitative data in addressing Interpol misuse. And it calls for the US to push Interpol to publish detailed statistics on WEN notices and diffusion requests, including how many are rejected and why. And while Interpol has started publishing some data since 2022, it remains insufficient. The lack of breakdown by country makes it impossible to track patterns of misuse by specific member countries, which is essential for identifying politically motivated abuse. And without detailed country-specific data, the statistics offer only a shallow view and failed to create real accountability. And this is not about shaming countries. It's about fostering accountability and ensuring transparency. And finally, as the TRAP reports confirm, the CCF remains a critical safeguard, but it is flooded with requests right now. In 2022, requests to the CCF increased by 37%, with over 2,500 cases annually. And these cases are becoming more complex. The CCF operates with a small team of just 15 people. And despite statutory timeframes meant to ensure timely decision, it can still take years for the CCF to reach one due to its caseload. And raising concern about its ability to provide an effective remedy. And to address this, I think it is essential to allocate more resources to the CCF. Specifically, increasing the number of lawyers to handle deletion requests will reduce backlogs, allow faster case resolutions, and ultimately improve transparency by facilitating the publication of more anonymized decisions by the CCF. So while important reforms have been made, the fight against the misuse of Interpol is far from over, and challenges remain, particularly in ensuring transparency and accountability to prevent politically motivated abuse. And without them, real life will continue to be affected. And reform is not a one-time event. It's an ongoing process. And with transparency, accountability, and persistent efforts, Interpol can continue to be a force for protection and not persecution. Thank you.
Thank you very much, Mr. Megre. I love the themes of transparency and accountability. I hope we can dig into that a little bit more in the question and answer as well. I was also remiss in not extending a particular note of appreciation to you for traveling all the way from France for this briefing. It means a lot to us to have your expertise represented here. And speaking of more expertise, Ms. Grossman, over to you.
Thank you so much, Mr. Price. I'm honored to appear before the Commission again, this time to discuss the TRAP provision's unfulfilled potential and what can be done to achieve it. When the TRAP provisions were passed, Representative Wilson expressed hope that it would stop Interpol abuse and prevent the U.S. from furthering the use of Interpol for unlawful purposes. Unfortunately, nearly 3 years later, these hopes for the TRAP provisions remain unmet, affecting the lives and individual human rights of many people. That's why this meeting is so important. The U.S. agencies responsible for monitoring and curbing Interpol abuse are failing to recognize and effectively report on this type of transnational repression. I will start by sharing a few examples and then making some recommendations. First, our client, a citizen of Lebanon, filed an arbitration claim against Armenia over an investment dispute. He filed the claim with the International Center for the Settlement of Investment Disputes, or ICSID, which is located here in Washington, D.C. The U.S. has been a party to ICSID since 1966. Months before the parties were scheduled for a hearing, Armenia requested and Interpol issued a politically motivated red notice against him. Shortly after, the Department of State revoked our client's visa. As a result, the client, the key witness in a high-stakes arbitration, was denied his right to testify in person before ICSID. Because of the war in the Middle East, he was also unable to travel anywhere to meet with his legal team. Our hope is that the CCF will soon delete the red notice as politically motivated. Nevertheless, due to Armenia's unlawful actions, made much worse by the Department of State's revocation of his visa, our client and his U.S. citizen children, as well as his wife, are trapped in the ongoing conflict in Lebanon, with bombs falling around their house as we speak. In a second similar case, our client filed an arbitration claim against another European nation. Immediately after filing, within a day, a nonsensical red notice was issued against him. This caused significant delays in his application for U.S. citizenship, as well as it posed tremendous challenges for the arbitral dispute. In June of this year, the CCF finally deleted the red notice, finding that though our client is not a politician, there was a, quote, substantial political dimension in the general context of the case, indicating that our client held, quote, politically relevant status due to his arbitral dispute. A third case involves Jessica Barahona Martinez, an LGBTQ woman who fled El Salvador because she was subjected to persecution from police. Upon arrival to the United States, she applied for asylum. Then, because of a red notice based on a bogus charge of extortion amounting to less than $30, ICE detained her, and an immigration judge denied bond. She was held in ICE custody for 6 years and separated from her 3 children. This was the case even though she was twice granted asylum by a U.S. immigration judge. Even after the trap provisions were adopted and the CCF deleted the red notice, attorneys for ICE refused to agree to terminate removal proceedings. Jessica is now finally out of detention and an asylee, hopefully on her way to becoming a U.S. citizen. But Jessica's story shows how TRAP is failing to protect many other people, including asylum seekers from all over the world. ICE continues to arrest asylum applicants and place them in deportation proceedings. Right before this testimony, I was made aware of a similar case involving another citizen of El Salvador, a citizen of Kazakhstan who's been fighting his case for over a decade, as well as numerous Chinese, Venezuelan, and Turkish cases. We also cannot leave out an increasing number of illegitimate red notice requests by Mexico. Numerous cases now handled by my firm show a similar pattern. Private litigants in business disputes obtain arrest warrants and red notices through graft and corruption to pressure their opponents. Mexico then makes a request for the notice to Interpol and sends a communication to U.S. immigration authorities. DOS, Department of State, seemingly automatically revokes the visas and global entry of persons both in and out of the United States, leaving them without a viable immigration status, subject to U.S. immigration detention, and protracted deportation proceedings. Again, all based on the unsupported allegations of a red notice. These examples demonstrate a pattern that both Interpol's Notices and Diffusions Task Force and U.S. agencies seem to misunderstand. Politically motivated Interpol abuse does not only occur when the targets of red notices are politicians, dissidents, or journalists. Those are the obvious cases. States also engage in Interpol abuse in relation to ordinary citizens who are either the victims of corruption or because they have challenged government action in some way, including through arbitration proceedings. In many of these cases, the criminal allegations contained in the red notice are not overtly political. They appear to be ordinary law crimes and often financial crimes. Neither the NDTF or U.S. agencies have the information to identify these cooperation requests as politically motivated. As a result, lives are ruined, visas are revoked, rights are abrogated, and asylum is delayed and sometimes denied. The following reforms are needed to successfully implement the TRAP provision's important goals. First, adopt a true, quote, whole of government, end quote, approach, and require interagency communication between Department of State, Department of Justice, and the various sub-agencies of the Department of Homeland Security, including USCIS, CBP, and ICE, to effectively monitor and report on red notice abuse. Require Department of State and Department of Justice to publicly issue statistics on the number, location, and outcome of Interpol cases. Third, task the U.S. National Central Bureau, or NCB, with a more proactive role to guard against bogus Interpol communications that Interpol and the NDTF might have missed. Fourth, for the Department of State specifically, develop trainings and adopt a policy for inclusion in the Foreign Affairs Manual, preventing consular officers from revoking visas based on an unsupported red notice alone. For the Department of Justice and the Department of Homeland Security, more emphasis is needed on how U.S. agencies play a role in perpetrating Interpol abuse through deportation proceedings, not extradition. Require training for DHS Office of Chief Counsel as well as Department of Justice immigration attorneys on how to assess the validity of a red notice. Finally, and critically, instruct the Department of Justice to coordinate with the Department of Homeland Security to ensure that targets of red notices, especially those who have applied for asylum and protection here in the United States and are accused of nonviolent crimes, are not arrested and are allowed to continue to handle their asylum cases affirmatively before USCIS. Adopting these recommendations would signal a real commitment to fighting transnational repression, one that moves beyond intention to real progress. Thank you.
Thank you, Ms. Grossman. That was extremely important testimony, and I have to say, I always enjoy, just as we did in our first hearing on this topic, concluding the opening statements with your testimony, because I think you bring us back to the core of this issue, which are the people's lives that are affected by this. I think this discussion will enter into a lot of technical details and statistics, that sort of thing, but really the reason why we're here, the reason why we care about these things, and the reason why we want to take these recommendations seriously is because of the people that are on the receiving end of these abusive notices. I think it's also an important reminder that you give us that it's not always just the usual suspects of authoritarian countries that are responsible for these abusive notices, but others as well. This is a pretty broad problem that spans a lot of different types of regimes and a lot of different types of abuse. So if I may just stick with you for 1 second, and well, before I go there, let me just say that you have provided us with even more recommendations here in your testimony, as have you, Dr. Broman, and I want to unpack those a little bit here in a second, but just to reassure you and our audience that all of that will be made available on our website and entered into the congressional record as well, so that can be a resource for others going forward. Ms. Grossman, just to go back to what you were discussing in terms of the ways that this affects people here in the United States who are the subjects of immigration enforcement decisions and otherwise. How does this even happen? I mean, if you could describe it for us a little bit of your understanding of how these abusive notices get promulgated, how they wind up in our system, how CBP, ICE, others reference these in order to inform their enforcement actions. Are they breaking existing rules? And when these things are called back by Interpol, when they are they deleted from our systems, or are we continuing to reference bad notices going forward?
Thank you for the question. So I think a critical point to understand for those of us monitoring Interpol abuse is a point that I made in my testimony, which is that this often occurs through deportation proceedings. At least that's what we're seeing in our practice. And ICE officers, which fall under the Department of Homeland Security, have broad discretion to arrest non-citizens in the United States. These are civil enforcement actions. And the pattern that we see often is an individual will apply for asylum, and they won't even know that they have a red notice against them. And they may apply affirmatively, for example, in a non-adversarial proceeding before the U.S. Citizenship and Immigration Services. When they apply for asylum, after they submit their application, there's a vetting process that is gone through by U.S. law enforcement agencies, including DHS. The person can then be apprehended pursuant to an enforcement action by ICE, Immigration and Customs Enforcement. They may show up at the individual's house. They may show up at an asylum interview, though that happens, in my experience, less frequently, although it happens. They may show up at their place of work. And what will happen is the ICE officer will issue them a notice to appear, which is a charging document requiring them to appear for removal or deportation proceedings before an administrative court, which is part of the Department of Justice. The individual then loses their opportunity to continue to apply for their asylum case affirmatively. Instead, they have to apply as a defense to deportation. And in that case, it can take 2 years, 5 years, 10 years for their asylum case to be heard because of the backlogs in the immigration courts. And then often, the individual may be arrested by ICE, and then you're looking at taxpayer expense issues. We're paying for these individuals to be detained by ICE, in Jessica's case for years. And after they're detained, they're often denied bond by immigration judges who don't understand that the existence of a red notice actually reduces flight risk because the person can't go anywhere. Yet you see ICE attorneys making arguments that the person is a flight risk. Now, I can understand it in cases where there are serious violent crime allegations, but it seems to be happening in cases involving financial crimes, and as we saw in Jessica's case, an extortion attempt. We saw a case last week in our office involving a gentleman from El Salvador that was accused of making Twitter or X statements against the president of El Salvador, who was detained by ICE. This was last week, or 10 days ago. And so that's what happens. You end up, because of a civil enforcement action, in protracted deportation proceedings. Now, that's one way, very briefly. The second way is for people who are outside of the United States whose visas get revoked. And here, the Department of State has broad discretion also to revoke visas. There's no right to a visa, but the issue is they're not giving individuals an opportunity to respond, to have an interview, to discuss the allegations against them.
Mm-hmm. So these agencies like ICE and state, are they under any obligation to do their own due diligence when they log into their computers and they see a red notice pulled up against an individual? Do they check with the NCB? Do they check with the State Department or any other agencies to verify the credibility of this information, or do they just plunge forward?
Well, with ICE, I will say one positive development that maybe was brought about because of the increased attention on Interpol abuse is that ICE issued a directive, I think it was in October of 2023, basically providing additional guidance to their officers that they should take a more nuanced approach on red notice cases. That was very welcomed in the advocacy community. Unfortunately, we haven't seen the same repeated with Department of State or other agencies. So they are supposed to be taking a more nuanced approach. I think in some cases they are. They're instructed to give an opportunity to the person that's being arrested to provide additional context about their red notice. We haven't seen that. We haven't seen that is happening. I imagine it takes some time for the guidance to filter through to the field officers, but that is there. And this is where the other recommendation that I made comes in, which is it's my understanding that these agencies do go back to the USNCB and confirm the red notice. And that's where the USNCB could really make a difference and act more as a safeguard against additional enforcement actions, provide more context, look at the case more carefully. I think we all recognize that all of these agencies are doing their job. They have limited resources, but there are certain steps that they can take to really safeguard against making the impact of the red notice even worse.
Okay, that's very helpful. And Dr. Broman, we would get back to your treasure trove of recommendations as well. So are there others that you would like to put on the table here for us to consider?
Yes, I would certainly endorse all the recommendations made by Mr. Megre and Ms. Grossman, and I have a number of others I would add. The first and most obvious one is that U.S. executive agencies should follow the law and implement the trap provisions as they already exist. Second, I'll just emphasize this again. It's of central importance that the U.S. National Central Bureau, the NCB, which is the organization in the U.S. government that's charged with handling communications to and from Interpol, it's essential that they take a position of being less about solely sending and receiving communications and more about intervening in the Interpol system when they see abuse. This is entirely within Interpol's rules. The NCB around the world are really supposed to be the first line of defense against Interpol abuse. I would like to see the U.S. NCB create a position of a public ombudsman who would be charged with collecting evidence on Interpol abuse and protesting that abuse to Interpol, thereby giving the NCB a more proactive role in opposing Interpol abuse instead of simply being a post office where messages are sent and received. Third, I would require regular public reporting by the executive branch to Congress on the number, the location, and the outcome of Interpol cases that are circulating in DHS, Department of State, and DOJ. Fourth, I'd mandate that ICE be required to disclose promptly to respondents whenever an Interpol communication plays any role at any point in an enforcement action. Right now, even these new ICE guidelines that Ms. Grossman referred to, ICE has placed upon itself the requirement to provide the underlying documentation, that is, an arrest warrant from, let's say, El Salvador. But they are not required, even by these new directives, to actually provide the red notice or blue notice or wanted person diffusion. That should always be provided in every case of an enforcement action. I would then also mandate that ICE, before making use of any Interpol communication to initiate or guide any enforcement action, be required to present that Interpol communication to the U.S. Department of State's Bureau of Democracy, Human Rights, and Labor for its review of the potential abusive nature of this communication. I would also ask that the U.S. support an increase in Interpol dues, with the funds to be dedicated to expanding the Notices and Diffusions Task Force and turning the CCF into a full-time review body. Right now, the CCF meets 4 times a year for 1 week for each meeting. Now, I know that there are very hardworking and dedicated staff who work well beyond those time periods, but the fact of the matter is that the CCF is a part-time body. It should become a full-time body and therefore be able to make headway in clearing some of this enormous backlog. I would recommend that the U.S. oppose the development of new Interpol initiatives that don't adequately preclude the possibility of abuse. There are a number of these. I'll just mention one. Interpol is relatively close to introducing a silver notice, which would be dedicated supposedly to fighting financial crime. This is a wide open goal for abuse. As Ms. Grossman has pointed out, a lot of Interpol abuse cases now center on allegations of broadly financial fraud, tax fraud, contract disputes, and so on. A silver notice based on financial crime will accomplish one thing. All the abuse in the red notice system will rush immediately to the silver notice system, and there will be a lot more of it, because abusive regimes love to accuse individuals of financial crime because it is so easy to make an accusation and so hard to disprove. Finally, I would recommend that the CCF return to its former practice of providing a breakdown by nation of the origin of its cases. The CCF used to do this in 2017, and even though the data was very partial, it was very revealing. The nation that produced the most CCF cases was always Russia. That shouldn't be a surprise to anyone. The CCF should return to that practice and publish more data on the origin of cases and the percentage of cases coming from each country that are actually found to be abusive.
Thank you. I want to stay on that last point for a second, because this is something that was explicitly called for in the TRAP Act, as you mentioned, something that our administration has deferred from doing, and it's a perennial conversation within this community about the effect of naming and shaming and the possible dangers, especially as we hear from our executive branch colleagues, of doing so. And yet, for both you and Mr. Megre, we've heard about the importance of transparency and accountability specifically, and for Ms. Grossman too, of course. And so I'd like to give you all the opportunity to share your views on why this is important, and maybe you could also help us to understand, are there really dangers to naming and shaming, and how would you weigh those against the benefits?
I am unpersuaded by the argument that revealing who abuses Interpol is bad for the system for a number of reasons. First, all of this abuse is against Interpol's rules, and we should be taking every effort to try to oppose it. Secondly, the idea that is advanced by the DOJ in the TRAP reports is that if the United States or other Interpol member nations exposes that Russia, for example, is committing a good deal of Interpol abuse, that Russia will stop cooperating with U.S. law enforcement. Well, I have profound concerns about the desirability of the U.S. cooperating with Russian law enforcement under any conditions whatsoever. And I am not particularly bothered by the idea that exposing abuse in the Interpol system will prevent U.S. law enforcement from cooperating with the Russians or a number of other systemic Interpol abusers. And finally, and I will return to this point, which I made in my testimony earlier, the real risk to Interpol is not in the exposure of abuse. It is allowing that abuse to fester until some individual who has been horrifically abused finds a way to make a legal challenge within the European system of justice that places Interpol at legal liability for its failure to uphold its rules, or until Interpol is responsible for allowing the abuse of a U.S. citizen who is both palpably innocent and extremely publicly appealing, whereupon the Congress of the United States is quite likely to hold a hearing and explain to the Department of Justice and the Department of State and Interpol that they should have done a much better job of screening their systems for abuse. Those are the real risks to Interpol going forward, not exposing abuse. It is the prospect of a legal remedy or a political remedy to Interpol abuse that lie entirely outside of Interpol's ability to control and could affect its effectiveness, its reputation, or perhaps even its existence.
Yeah, maybe just want to add that I think there is a difference between publishing a list of countries abusing Interpol mechanism and just publishing detailed statistics with a breakdown by country, with a number of when notices request and wanted person diffusion request, and the number of conciliation by the General Secretariat. I think there is a huge difference because when you are just publishing neutral statistics, you are not shaming countries. It's just accountability. This is not a list of countries abusing Interpol mechanism. This is only a list of statistics. And I would advocate more to have detailed statistics with a breakdown by country rather than publishing a list of obvious countries violating Interpol's rules.
Go ahead.
I'll just add that I think the question about increased transparency is a question of priorities, right? Interpol is mandated, it has a neutrality mandate, and Article 3 requires it not to be involved in cases that are predominantly military, religious, or political in nature. So if that is the mandate of Interpol, then transparency can only help nations and Interpol itself to meet that mandate. A more transparent Interpol, a more transparent CCF will also assist U.S. agencies and agencies in other countries who are processing red notices that look to be facially legitimate. So why should they question them, right? That's the issue that we see so frequently. I also think for people that are advocating for deletion of red notices before the Commission would be greatly assisted by more information from the Commission. The Commission's decisions are heavily redacted. I understand that's needed sometimes to protect the privacy of individuals, but there's other places where it would be helpful to protect individual rights to have more information. So again, it's a question of priorities, and to me it seems clear that human rights and protecting fundamental human rights should be the priority.
Thank you. And Mr. Megre, I think you added an important nuance to my question, which is that it's not just a naming and shaming exercise. This is an objectivity question. This is a question of, and all of you hit this point as well, that this is important for the institution to continue to exist and live up to its own mandate and constitution. So thank you for that. I wanted to talk a little bit about the statistics that have come up a few times in your presentations. It strikes me sometimes when I look at these statistics that this is just capturing, when I speak of statistics, I mean of the number of abusive notices that are being detected and rejected by the CCF or by the Notice and Diffusion Task Force as well. And it strikes me that this was really only capturing the universe of abusive notices that are being detected. And so my question is, what are we missing? Do you have a sense for the scale of what's going undetected? Is there a way of approaching that? I understand that it's unknowable in some regard necessarily, and yet are there sort of proxy statistics or ways that we can conceptualize what might be missed? I was struck in particular by the statistic that you shared that 70% of what goes before the CCF is found ultimately to be abusive.
That's a really good and complicated question. I think that more and more applicants are aware of the existence of the CCF. That's why there is more and more requests presented before the CCF. And I think that 37% of increasing in the number of red notices of the requests presented before the CCF is a number highlighting that more and more applicants are aware of the CCF. And what is missing in number of non-compliant cases is really complicated to answer. Honestly, it's quite impossible to just say that it's in between that number and that number. I don't know. I will say that it's in between 6% because this is the number of the NDTF, and between 70% because this is the number of the CCF. And there is somewhere an in-between number, but I cannot answer to that question. It's impossible. It's impossible to have a detailed statistics on that. I don't know.
Anyone who wants to hazard a response?
Well, I don't have all the answers, but I will say this. We can tell a little bit more about what we are missing by looking at the backlogs before the CCF. So by the CCF's own statute and rules and procedures, they're supposed to make a decision on a request for access within about 4 months and a request for deletion within 9 months. For requests for access right now, it's taking more like 6 months. For requests for deletions, it's taking more like 1.5 years. And if you have a request for a revision of a decision that the CCF has already made, we had one case that took 2.5 years. So that gives us some insight into how many cases are pending and the fact that the Commission is severely backlogged. The other thing that we're missing, and I've been focused more on what's happening with agencies in the US, is we're missing statistics. We're not getting statistics from Department of Homeland Security, from Department of Justice, or from the Department of States about how many of these cases are circulating through our system. Why not?
It's worth talking just briefly about the Notices and Diffusions Task Force and their initial screening process. So a request for, let's say, a red notice comes in to Interpol. It goes to the Notices and Diffusions Task Force. Under Interpol's rules, Interpol is mandated to assume that all information received from a member state is accurate and relevant unless Interpol knows otherwise. Translating that into sort of more layperson's language, the Interpol system assumes that the state is right and the individual is justly accused. That is the beginning assumption of Interpol. And that is not an arbitrary assumption. It is explicitly written into Interpol's rules. So the system begins with the assumption that the state is right. The NDTF then looks at the red notice and tries to figure out if there is a reason to override that assumption that the state is correct. It has a couple of things it can look at. It can look for information in the Interpol system. Well, all information in the Interpol system comes from member states. Interpol is not the CIA, it's not MI6, it doesn't have independent intelligence collection sources. It's very unlikely there'll be anything in Interpol's files that provide the basis for rejecting a red notice. It could happen, but it's unlikely. Secondly, Interpol or the NDTF does a Google search. Go to Mr. Google and see what you find on the individual named in the red notice. Now, if the individual is William Browder or Gary Kasparov, you will find reams of information about these individuals online. And Interpol is highly unlikely to publish a red notice on any of these individuals. But if the person is not a public figure, doesn't appear in any easily searchable source, there is no reason for Interpol to reject that request. The presumption of state rightness applies. The red notice would be published. And third, the NDTF can look at the technical aspects of the red notice. We all could go into this at great length. This is where I think the NDTF sometimes falls down on the job. I have seen red notices, and in fact, with permission, I have published a redacted red notice where the red notice was clearly technically deficient. My concern is that the belief under the rules that the state should be presumed to be accurate, plus a certain amount of time pressure, leads the NDTF to approve a number of red notices, probably a substantial number, judging by the workload of the CCF, that it should never have approved. So I think we shouldn't just fall into the trap of saying that Interpol is incompetent or malicious. I don't believe either of those things are true. Their rules are structured in such a way that it's difficult for them to make the right decisions. They lack information, and sometimes I think they don't do a very good job of following their own requirements.
Thank you. It's all very illuminating on a very difficult question to answer, as you mentioned. I should have mentioned this earlier, but there will be an opportunity for members of the audience to also come up to the mic and ask a question. So I'm going to continue to use the prerogative of the moderator here to ask another one or two questions, but then I'll look for contributions from the audience as well. So I wanted to ask about, I referenced this in the opening, the upcoming General Assembly meeting that will be held in Glasgow starting next week to elect a new Secretary General and Executive Committee for the organization. I was wondering if you could comment on what the impact, what outcomes do you expect from those elections, and what will the impact be on this kind of human rights focus that we would like the organization to take, and what the likely outcome is to be?
Thank you for that question too. The upcoming Secretary General and Executive Committee election are obviously crucial for shaping Interpol approach to human rights. And my opinion is that Valdesi Urquiza appointment as Secretary General offers both potential and challenges. His focus on and this is my understanding, on keeping Interpol as a technical platform free from political influence is, of course, encouraging. But the real test will be how that vision will be translated into action. And his background in international law enforcement, he keeps him to improve the filtering mechanism of the NDTF, which have been historically prone to abuse. And regarding the executive committee election, the executive committee also play a key role in setting Interpol priorities. And the new member focus on transparency, especially in publishing some data on abuses or corrective measures adopted, could greatly enhance Interpol responses to human rights concerns.
I would like to see Interpol adopt a human rights-centered approach, but we should recognize that Interpol is an organization that is almost exclusively run by and for policemen. And it is unlikely that under the leadership of any Secretary General, that Interpol will move as far towards a human rights-centered approach as I might wish. I want to give the incoming Secretary General Valdeci Urquiza of Brazil, who has been nominated by the Executive Committee and will almost certainly be confirmed by the General Assembly at the meeting in Glasgow, a fair chance. I do, however, have some concerns. Mr. Urquiza ran in his public remarks before being selected by the Executive Committee on the argument that Interpol should be separated from politics. Now, that sounds good, and I fully endorse that approach. But in his remarks, Mr. Urquiza appeared to argue that politics are when one member nation, let's say the United States or the United Kingdom, leads a campaign to suspend another member nation, like Russia, from Interpol. That is political under some definitions of the term, and a non-political approach is allowing absolutely everyone to stay in Interpol and not separating the sheep from the goats. I'm much less happy with that understanding of the term political. I would say that regardless of what Mr. Urquiza believes or doesn't believe, he will not be an unconstrained actor. Interpol has staff contracts. Staff cannot turn over rapidly. Many officials in Interpol are seconded by member nations. Interpol has a budget which is set in advance, which must be followed. It cannot be easily varied. Ultimately, the Executive Committee is responsible for ensuring that the Secretary General follows through on the votes of the General Assembly. So there are many constraints in the way of any Secretary General to do good things or less good things. But I would have preferred it if an incoming Secretary General took a strong stand not against, as Mr. Urquiza has said, the politicization of Interpol per se, but had taken a stand on the rules and the Constitution of Interpol should be upheld fairly and without favor against all Interpol member nations. That is not political. That is being apolitical. If he has that understanding, then I think that his actions are likely to be extremely satisfactory.
Does anybody else want to comment on that before I turn to the audience? Sure. Now, if anybody wants to raise their hand or just go ahead and proceed to the microphone with a question, you are free to do so. Or I will continue to abuse my prerogative here as moderator to ask questions. Yeah, go ahead, Paul.
Cool. All right. Well, thank you very much. Terrific panel. I mean, it seems to me that there's two separate issues mostly that one has to tackle, and that's how the United States handles Red Notice, and of course what happens in Leon, basically, kind of like what happens institutionally at Interpol. And I mean, I think our leadership by the way, Paul Massaro, the staff director of the Helsinki Commission, but our leadership tried to look at both of these things. Obviously, we can't legislate what happens in Lyon, but we can look at how the United States takes a position. And it kind of alarms me, I guess, Dr. Broman, you know, what you say about the incoming SG and kind of his positions, because we've heard this before in other international organizations, this sort of promise not to be political, meaning a promise not to hold those who abuse these organizations to account, essentially, is what that very often means. And I guess I wonder, what is the appropriate U.S. posture within Interpol? What should the United States delegation there be doing? And should the USA be, I mean, should we be pushing harder for the suspension of other states? Should suspension really be on the table? I mean, you know, obviously, I guess I come from this mostly of the position of yes, but I'm certainly interested in what, you know, our experts think.
Thank you, Mr. Massaro. Pleasure to see you. There are a number of points of view on this. I will offer mine. I believe that unless and until an Interpol member state is suspended for persistent, flagrant, and gross abuse, that abuse will continue because it is cheap, easy, and very effective. I think Interpol needs to establish deterrent power by showing that it will suspend a member state, which will reduce the incentive for other member states to commit similar kinds of abuse. That does not seem to be on Interpol's agenda. It was certainly not under the agenda of the outgoing Secretary General Jürgen Stock, who said repeatedly and publicly that there were no suspension provisions contained in the Interpol Constitution. Mr. Stock was correct about that. Those provisions are contained in the Interpol's rules on the processing of data, a fact that he never added publicly. So it is very clear to me that Interpol really does not want to suspend member states. What should the United States be doing about this? I would love to see the U.S. cooperating more visibly and more obviously with fellow democracies inside Interpol. It is worth bearing in mind that we, together with our democratic allies, pay well over half of Interpol's budget. The United States in particular pays 20% of Interpol's budget. I would love to see a more cohesive democratic approach inside Interpol, offering a relatively few, very well qualified, and by no means always American candidates for the executive committee, for the CCF, where U.S. leadership has been outstanding. That in and of itself is not going to solve the problem, but we certainly have the financial clout. We certainly have individuals with more than sufficient ability and competence, as do many of our democratic allies, to take a much stronger leadership position inside Interpol. That won't lead to us winning every battle, but the CCF is a much better body than it was a few years ago, and that owes very significantly to U.S. leadership on this. We can make a difference with our democratic friends when we want to. I think we should want to, and we should coordinate a little bit more to make sure that that happens.
Does anybody else want to comment on that? I thank Paul for the question. You anticipated something that I wanted to conclude on, which is the role of the United States within the organization. I think that's super important. And Paul and I worked very closely together in making the TRAP Act come into reality with the support of so many important experts from outside Congress. So I guess I'll ask one more question that's kind of near and dear to my heart, because it's what initially put me on the path of learning about authoritarian abuse of Interpol, which is the abuse of the little known but very important stolen and lost travel documents database. I came at this from the perspective of a policy advisor that was responsible for covering Turkey, and Turkey was abusing this database extensively in the wake of the attempted coup in 2016, in which it used the database to fraudulently assert that a bunch of Gulenists, other opposition or dissidents to the current government in Turkey, had stolen or lost or had their travel documents lost, and this would essentially freeze their ability to travel either outside of Turkey, or once they got outside of Turkey, they would be stuck in other countries without the ability to travel onward. So I think there's a lot of press attention that's given to the red notices, the other colored notices, but a stolen and lost travel documents database, I think, is doesn't get enough attention. And so I wanted to just ask anyone who wants to comment on that, kind of what is the role of the database? Is there a way to prevent its abuse, especially at the scale that we saw following 2016 by Turkey in particular, but certainly by other member countries of Interpol?
Thank you for that question. The SLTD database was originally meant to track lost or stolen passport travel documents, but it has expanded to include invalid and revoked travel documents. And there are limited safeguards in place for the SLTD database, unlike red notices, which make it easier to misuse. And as you said, some government has been accused of falsely reporting dissidents' passport as stolen, revoked, or invalid. And I think the problem with the SLTD database is the fact that the lack of detailed information provided for each entry make it difficult to establish proper oversight mechanism, leading to the potential for misuse. And to address these issues, I think Interpol should introduce clear rules for entering data into the SLTD database, and I think that these rules should be explicitly included in the Interpol rules on the processing of data. For example, before a passport can be revoked and recorded as such in the SLTD database, I think that the court decision should be required to ensure that there is a legal ground and it's not only based on political motivation. And furthermore, while pre-compliance checks on every single entry may be challenging due to the vast amount of data recorded each day in this database, I think that Interpol should consider establishing some sort of review mechanism to at least perform basic checks on data submission. And I think introducing such measures will significantly reduce the misuse of this database.
Go ahead.
Mr. Megre raises an important point there at the end about the vast amounts of data. I agree entirely with all of the reform recommendations. This is a challenging issue for Interpol to deal with, but it illustrates that Interpol abuse is like a balloon. You squeeze it in one place, and the abuse tends to go somewhere else. The red notice system is by no means perfect, but I think I would certainly say that some important reforms have been made. They're not sufficient, but they're real. But that has tended to squeeze the abuse into blue notices, into wanted person diffusions, into the passport system. And so, as Mr. Megre said in his opening remarks, the process of reform is not a one-off. Regimes are very clever and people are very inventive. If you make it harder for them to abuse the red notice system, they will start abusing the stolen and lost travel documents database, which is precisely what they have done. My larger concern about this, the amount of data that Interpol is pulling in, is that we have been talking all this time about Interpol as largely a kind of a post box, a messaging function. Red notices go from one place out to other places. That's true, but Interpol is also transforming itself into a collector of very large amounts of nationally provided data and developing analytical capacities to process that data and return the so-called compliant, that is, the non-abusive results, back to the member states. The latest changes in Interpol's rules on the processing of data allow Interpol explicitly to take in large amounts of data that is subject to no compliance checks whatsoever, process it all, and then before they spit the results back, they're supposed to figure out which ones are the compliant ones and which are uncompliant, and just don't send the compliant ones back. I guarantee that if Interpol continues to go down this route, the next frontier for Interpol abuse will be using Interpol to plow through terabyte after terabyte of data, and then just hoping Interpol kicks back, or ensuring that they kick back by manipulating the data, the people that you want to target, and recognizing that Interpol will not be able to effectively police these enormous databases that it is collecting. This is the problem of the travel documents database, except a lot bigger. So I really encourage Interpol and the U.S. to keep on following up on the abuse story, because as long as there are abusive regimes out there, and as long as Interpol keeps on coming up with new notices, new databases, and new processes, abuse will continue, and it will keep on changing in its form, not its seriousness.
I think that's a great note to end on. I think this panel has absolutely accomplished the goal that we set out for ourselves, which was to take stock of where this issue stands 3 years since the enactment of the TRAP Act, and to plot some ideas for where we should take this effort going forward. As I mentioned earlier, your written testimonies are full of tremendous ideas for further reform that we'll be taking into consideration here at the Helsinki Commission, and hope that others can also benefit from those documents as a resource. So I want to just offer my sincere thanks to each of you for all the effort and thought that you've put into your presentations today, Mr. Megre for the many miles that you've traveled here, and to our audience for their attentive engagement and participation in this event. And with that, I will conclude the briefing. Thank you.